already, do me a big solid. Hit that subscribe button for me, y'all. Tap that little bell notification icon so you get notified with all the latest content, updates, and information from me, Straight Talk TV. Hit that like button, let YouTube know you rocking with this here content and you want to see more of it. And yeah, y'all, let's jump into this.
Disclose it. So, because this is why I've told you all, get together earlier, talk to one another, and if you have problems, then certainly or issues I need to resolve, file a motion, let me know so I can go ahead and take it up. But I'm hearing about it a lot of times the first time when the jury sits in a box. And I can't do that. It's not fair to them, not fair to me as your trial judge to be able to rule on those kind of things. So related number 3 is I'm going to start, if appropriate, and I do need to take up something that is of that important or import, I will go ahead and excuse our jurors, and just we'll take whatever, and we'll come back the next day. So that's 3. Number 4 is I have spoken with our sheriff, and consistent with court, if necessary, need be, we'll start having court on Saturday and Sunday.
Whoa, court on Saturdays and Sundays? Oh my goodness. Yo, this is Steve Franchise. Y'all are checking out, Judge Glanville from the YSL trial. And today they had a motion hearing. And I don't think Judge Glanville is playing around no more. Y'all gonna see and y'all gonna hear, throughout this motion hearing today, he's basically letting the defense and the prosecution know, look, man, I ain't playing around no more. Y'all need to speed this up. He's even gonna make references to this needs to be done before the next Super Bowl because they ain't trying to be in there on Super Bowl next year. So the prosecution and the defense has been warned. That's their timeline. Look, this needs to be done by Super Bowl. But y'all, let's check this out though.
Yeah, well, that's my call. So if you don't want your Saturday and Sunday sucked up, I think we need to work a little harder in terms of being able to streamline, and that goes to both sides. And look, I don't want to work that way too, because it's me and my staff and my team and the sheriff and his team and everything else. But we will do it because we're going to have to recap some days. I don't want to be in 2027 trying this case. Or as Mr. Steele said, I want to be here next Super Bowl trying this case. I'd like to have it. I'd like to watch the Super Bowl without having to come back to try your case. I hope that your case is resolved by that time, whatever may happen. But I think that we can do a better job at presenting the evidence and streamlining whatever for the fact finder to be able to make a decision. So we're going to start gathering on Saturday and Sunday. And the last remedy, and I don't say this being otherwise mean and contrary and everything else, but I have power of contempt. I don't want to use that.
They don't want to use it.
But
they don't want to use it.
It's come down. We've been in trial a long time. I think I've been very clear with everybody about my expectations, which serve you all and your ability as advocates in this case to try the best case you have. So that's why I said I wasn't going to kind of let you all start pointing fingers at each other, because I think there's enough blame to go around. But you all are going to have to, as I've said before, do better. You
Gotta
all
do
are
better.
very seasoned advocates. So I
Yes,
shouldn't
they
be
are, Your
having these many discussions and interruptions. I mean, and I'm in no way saying you're not doing your jobs, because that's what you're paid to do. You are doing your jobs. But the challenge to the court is that we've had a lot of interruptions with the jury sitting in a
Too
box.
many.
I've told you my concerns about that.
Yep.
So that's where I'm going to draw a line.
Yep, because the prosecution, whenever the defense is trying to say anything, the prosecution is jumping up every 20 seconds, seem like objection, Your Honor. Objection. They object to everything. As soon as the defense starts speaking, the defense can say, and on this day, then the prosecutor gonna jump up and say, I object, Your Honor. What are you objecting to? But yeah, I totally agree. Stop that nonsense. We gotta speed this up.
thought long and hard after these motions. I was thinking about this prior to Mr. Weinstein filing his motions and his supplemental motions to limit the witnesses, but I have to do something that will at least make us or force us to go ahead and make sure that we can present a case to the jury that is more streamlined and not stops and starts. I mean, if we get 2 or 3 hours a day, we're doing good because we had so much interruption. And a lot of that interruption was needless. It could have been taken up much earlier. So that's where I am at this point in time. Now, back to my original ask, Miss Love. How many more days do you think that you'll have?
Your Honor,
How many more days and witnesses do you think you'll have?
we think about 150 witnesses, Your Honor, and roughly 100 and so roughly 120 days.
120 more days.
That's 4 months.
150 witnesses.
Have you all now? Is this 120 days of actual like 5 days a week or what?
Right. We were trying to. This is what we were trying to achieve. This is what we're trying to achieve. That's what
Man,
So we were trying to, with the tearing down and with the previous information I shared with counsel for the defendants, this is what we were trying to achieve with our prior requests and information.
that's not going to work.
But that's not inclusive of the length of time it would take counsel to cross-examine all of our witnesses. We don't.
Listen, y'all. On top of the amount of witnesses they've already called and got nowhere, they want to call, I think, 150 more witnesses. What do you need 150 more witnesses to say? Wow.
Just don't have that. We can't factor that in. We don't have any way of estimating that or factoring that part in.
Are these may call or will call witnesses?
The
witnesses you
remaining witnesses are the definitely will call. There may be more. These are the ones that we have pared it down to, Judge. We made our best effort. We don't know if something will arise that will require that we pull in another witness that we provided the defense notice of, depending on how the witnesses change their testimony based on whatever questions are asked during their examinations. There may be occasions where that number changes, but that's the number that we have provided to counsel for the defendants previously, prior to this motion being filed, and that is the number that we expect to be able to present our case with.
Wow. That's a lot more witnesses, y'all. For real. That's a
Okay.
lot more witnesses. He finna get to telling them, no, look, y'all gonna have to speed this up.
Oh, you sit down, man, please.
He said, you can sit down, madam. Just go and have a seat. That's the polite way of saying sit your ass down. Sit down. Have a seat. Hey, man, this is crazy, but
This is the number of witnesses. This is the most pared down. This is what we expect that we will be able, we hope to be able to prove everything that we intend to put before this jury in our case in chief with these witnesses. If something goes differently than we anticipate, if some objection is made, if that is sustained, that requires that we call in an additional witness here or there to prove particular points, then we would supplement that list to that extent, but we don't expect that that would increase our numbers by any great percentage.
Okay.
So this is for the entirety of the rest of what we anticipate presenting to the jury in our case in chief. So it
there's
includes
still 150
the
more
counts on the
people. What are you
indictment.
talking
It
about?
includes overt acts, intrinsic evidence that we intend to introduce. We have
Yo, this case
served
gonna
upon
last a
counsel
long
for the
time.
defendants all of the acts, intrinsic, overt, that we intend to introduce evidence of. And so there's nothing within those witnesses that is not contained in the information that we have provided in terms of what we intend to prove. But this is as pared down as we've gotten it.
Okay, so these are the list of 150 are your the witnesses you will call.
Yes.
Okay, all right.
Wow.
Here's what I want you to do.
150 witnesses you will
Pursuant to
call.
OCGA 1716.3, I want you to update your witness list. You have the ability to call anybody that to supplant or not supplant, supplement, depending upon what other evidence is adduced or is presented that may require you to impeach or rebut or to the like.
Y'all watch
to
this.
to
She
account
not
for
gonna like what he's
variances
gonna say.
in presentation of evidence. So I'll allow you to amend to supplement your witness list, but for good cause.
150.
But I want to see the 150. I want to see them in terms of the law enforcement and what they're going to testify to, and lay witnesses and what they're going to testify
She's looking like, what?
pursuant to counts, overt acts, and/or counts, and any expert witnesses that you were going to call.
Okay.
Wow, she finna
So that
go
I understand, the
stuttering.
court isn't asking that we give the strategy to, the court is just saying, generally speaking, this
She
act, this,
worried
that,
about,
this, the other.
y'all notice she replies back with, oh, the court is not worried about giving up the strategy and all of that. This lets you know this lady is not thinking, legally and fair as a prosecutor. I mean, like, she just totally told on herself. She's not thinking about fairness and justice during the prosecution of this case. She's worried about the defense knowing the strategy. Now, reason why I say that, y'all keep in mind, right? During the process of a trial, the defense has the right to any and all evidence that the prosecution has. The prosecution does not have any right in a trial to withhold any amount of evidence from the defense, whether it's just one page or one sentence on a page. the prosecution has to turn over any and all evidence to the defense so the defense can prepare defense for what the prosecution is trying to say. She's admitting to not wanting to turn over information and evidence to the defense because she's worried about a strategy. You know, I'm telling you, she's not thinking about fairness and justice. Something to keep in mind, people.
At this point, there's not any. One of your predecessors told me once, said, "I'll give you my entire file because if you can beat me with it, you deserve to win."
Facts.
And I think at this point in time, the caliber of lawyers that you have in this courtroom, there should be no surprises.
None.
And I'm of the opinion that more disclosure just fosters openness in the proceedings and with what's being presented. So at this point, it's not like anybody's going to be surprised with anything you come up with. At least you shouldn't. There shouldn't be. But I think that in order for us to keep this thing going smoothly or as smooth as possible, the less interruptions that the court has, the better off we'll be in terms of evidence and presentation in front of this jury. So I want that by tomorrow morning, because what I'm going to do is I'm going to take a look at my calendar and we're going to kind of block it. I'm going to see whether or not we are going to meet 4 months or not.
That does not include the length of time.
Well, you can come on the weekend, Mr. Matthews. So don't worry. So don't
You
worry
come
about
up
that.
here on
Okay,
Saturday
you let
or
me
something.
take care of that. But okay, but that's part of the calculus.
I was going to say that does not include the length of time that.
Sure, I know that. I know that. But what it does is it kind of puts us on a path that at least I'll know and your colleagues will know, hey, where we are in terms of, so I can start to plug and play and see if we're behind. Because we're behind, I'm going to make you come during the weekends.
Okay.
Yep.
I mean, I'm just going to start
Saturday.
doing that because
In court.
we need to kind of press a little bit harder, or else,
That was tough.
as
Very
Mr.
bad.
Weinstein has said, we'll be here in 2027. And that's
Imagine
not
being
what I
on the
want
jury.
for this jury. We need to put this case to them in a fashion that is fair and reasonable. But I think that at this point in time, Ms. Love and all defense counsels, I think if you iron out and we don't have these hiccups where you all are like, where the state says, well, we gave you 3 things in discovery and now we have 5. And the defense says, well, I need to take up these other 2, which we haven't been given, or we got them this morning, or we got them a couple of days ago, and I haven't had their opportunity to do that, and you want to go ahead and present them. So that's why I'm saying if you all talk with one another, I mean, you might be able to, I know that you want to present the cases linear as you can in front of the jury, but sometimes that may not be we might not be able to do that because of what comes up. So I'm going to help focus you all a little bit better.
Your Honor, what you're
Tell
saying
them, good. I'm finna get y'all on track.
second point
I'm
that the
finna get
court,
y'all mind in the
will be
game.
implementing in order to facilitate the presentation of the information to the jury.
That's the exclusion?
Yes, of any documents not timely disclosed. So when we stand up, Your Honor, to present or to show something to the witness, it will not include anything that has not been served. But what we are doing is showing to counsel for the defense the numbered exhibits.
Here's what I don't want to hear. Here's what I don't want to hear. Ms. Hilton, a couple days ago, we just found this last night on the person's Instagram.
Your Honor, so
okay, that's what, and then
it was just it had just recently been posted.
Well, then you should have grabbed that, and whatever time that it was given to you, if it was 6 o'clock in the morning, should have been forwarded over to them, so they can kind of say, "Look, this just got posted," whatever else. Then that's kind of everybody knows.
That's the way it's supposed to go,
Introduce that evidence, and
Mr.
then they can talk with their client or whoever else that posted it, and they can kind of say, "Well, they can have meaningful discussions," but it shouldn't be done right while our witness is on the stand. That's just another example.
Facts.
Yes,
okay, I mean, that's what I'm saying to you. I mean, in terms.
Listen, for her to be a prosecutor, and a seasoned prosecutor, she's supposed to know this. She's supposed to know it.
In terms of if you get something, it needs to be disclosed immediately, and then you need to kind of let the court know first thing in the morning or as early as you can, saying, we're going to have to take this issue up. What I'm finding a lot of times is the witness is on the stand or the jury's in a box, and we're having to take up that. And we're doing
Yeah.
that more often than we are the exclusion rather than the rule. So that's what I mean.
Your Honor, and will the court also just mandate that we provide to each side our numbered exhibits prior to even approaching the witness with them, so that we have them? Because
It would be helpful because if look, if you've already disclosed those in discovery, but what I'm finding is happening is your colleagues say, nope, we haven't gotten that. But you should be able to tell me, Judge, we gave it to him on June the 15th, and it was in this particular disclosure, and this is where it was.
yes,
Because that's part of their challenge. I mean, they're like, we got 8 terabytes worth of stuff.
we have been providing to them the exhibits we intend to introduce. We're just asking that that be required of both sides, so that, for instance, before Mr.
But you're the
Cole or
one
someone
breaking the
else
rules.
approaches the witness with
I will make that as part of the defense if they wish to go ahead, and as long as it falls within the rules of the rules that remember.
that we
They're not in their case in chief yet,
No,
and they don't have to do anything. So part of the rules don't necessarily apply to them the way they apply to the state at this time. And I know that's frustrating, but that's just part of it. But to the extent that any defendant's going to use any evidence that I'm going to need to rule upon, I do need as much notice as I possibly can at
And
this
Your Honor,
point.
what I'm specifically speaking of are physical exhibits that are numbered. There may be on a PowerPoint 25 pictures, and we can't even pose or make an objection or say we don't have any if we don't know what exhibits we're looking at. So we're just asking the court require that we be given a physical copy.
But a lot of times, this is evidence that you've already given them.
It is. And so if they're giving it to the witness, we don't know if it's defense 1, 2, 3, so that we can know what it is we're objecting to or not objecting to.
Ma'am,
So
you
that
just
it's
up
not
here
just on a
talking.
computer. If we have a physical copy of it, like we provide to them,
She just
labeled
arguing to
already,
be
then we
arguing.
can make a more expeditious announcement to the court.
She arguing about nothing, basically.
To the extent that the defense has any materials, it would be helpful for you to show those to the state prior to your presentation, so we don't have delay to the extent that you can. So I'll make that part of my order, but it's really going to depend upon.
And Your Honor, I don't mean far in advance. I mean prior to saying we're approaching with some pictures, so that we can at least know what it is that we're talking about, like defense 1 through 12. If we could just have them, a copy of them, that would be great.
Well, I'll say this: as long as if it involves anything that wasn't disclosed in discovery, because you all should have those. I mean, Ms. Love, I think part of it is they're using evidence that arguably they got in discovery. So that shouldn't take that much. That should not take much looking at, nor should be a surprise to you.
Facts.
However, if it's something that's not been provided in discovery that they wish to go ahead and examine, I would say that probably needs to be disclosed consistent with reciprocal discovery rules.
Yes, Your
Yep.
Honor, and I do not mean to disclose it to us. I mean, no matter what it is, just so that it's labeled, so that we can properly speak that it's labeled so that we can properly speak to it on the record. If they
She
know that they
arguing
are
about
introducing
nothing.
12 pictures that the state has provided in discovery, and they are calling them defendants 29 through whatever, if they would simply say, okay, here are the pictures so that we can speak to them even when we get up to redirect. Okay, I'm going to show you what has been marked as defendants 29, 30.
So are you saying it's a labeling issue?
It is. And providing to the state which exhibits comport with which defense number. We have had the circumstance where the computer is taken to a witness and the witness is shown unnumbered photographs, and we have had to stop and say, we need to know what is being shown and how you have labeled them so that we can speak to them.
I understand. All right, so both sides can do that. Remember, if you show a witness a document, even if it's for refreshing recollection or whatever, or it's not admitted, it still has to be identified for purpose of record. So I'll ask that all of you do that. All right. What other issues haven't I dealt with pursuant to your motion, Mr. Weinstein?
Thank you, Your Honor. I just hope I get some clarification.
Sure, to the extent I
Sure,
can
the
give
court
it.
understands.
Oh man,
but I
this
don't
guy here is
understand. When the
hilarious.
state says they have 120 days of direct examination, that's 120 court days, correct? So we're looking at about 6 months more of their case in chief, assuming we ask 0 questions on cross-examination. 120 days, is that 4 months? Or is that, if we're going 4 days a week, for example, are we talking 30 weeks?
We're talking 120 days.
120 court days.
Are you talking about 120 court days?
Yes.
120 court, assuming no, and then we have to add in our cross-examination. So we're here with the state's case in chief through the Super Bowl.
That's 6
No
months.
Super Bowl for y'all.
Or more.
Yeah.
Okay.
And Your Honor, that is a it's not precise, and I can do more. It's as precise as I can give to the court at this moment. And Your Honor, I have stated to the court and to counsel for the defendants where it was that we were trying to conclude this case by.
Your Honor, I'm sorry, can I go? Yeah, sure. Your Honor, courts in the 11th Circuit, the 7th Circuit, the 5th Circuit, the 3rd Circuit, the Western District of Pennsylvania, the Northern District of Iowa, the Eastern District of Kentucky, the District of Mass, and I could probably go on and on if I had more time to research, have used the combined power that you have under 403 and 611 to limit witnesses, limit the number of witnesses, and or put time limits on the state.
For real, because that seems like a lot of witnesses. And listen, y'all, you've seen the witnesses that they've called up until this point in this trial. Do any of these witnesses seem like they want to be here? And y'all got to keep in mind, these are witnesses that the state is calling. From the guy who said he can't remember nothing to the guy that said that, none of these defendants is, part of a gang, to the female they just had who said no, them was not the guys who robbed her. Like, we got to go through 150 more of these type of witnesses, y'all. The judge got to be able to do something to speed this up. For real.
What I sent you this morning, just to clarify, and I should have made it more clear in my email, and that is my fault, was those were not additional arguments or amendments to my arguments. Those were courtesy copies of cases that were cited in the motion or additional cases that I was going to use in my argument. And that was just for the convenience of the state and for the court, so y'all didn't have to pull those up. But they weren't last-minute arguments. But Your Honor, and I'll sit down after this because I do believe that you've already made up your mind. But I would just ask the court to reconsider, because I do appreciate that you're trying to grab the bulls by the horns here and make us more efficient. And I don't doubt that those 5 rules that you've put in place will make us more efficient.
So, that's the proceedings. And, the judge put in, some rules to try to help speed things up. As you see, the state is trying to call 150 more people, which is she's expecting to take up 120 more days. Now, y'all got to, keep in mind that that's 120 more days without any defense cross-examination. So when you factor in the cross-examination from the defense side, you're looking at about another 120 days. So in all, you're looking at about another 240 days of court if the state is allowed to call 150 more witnesses. 150 more witnesses going to equal about 240 more days of court. At 5 days a week, you do the math. They're going to be there for a long time. And the judge is like, hey, we got to find a way to speed this up. If y'all don't, get your act together, we're going to start coming in on the weekend. Well, we're going to get this done. You know what I'm saying? So it's crazy in there. And, especially them long days where the prosecutor is just subjecting to everything on cross-examination. That's drawing it out even longer. Oh my goodness. And y'all, this case is a real eye-opener on just how sometimes, not all the time, but sometimes prosecutors and district attorneys can just completely waste taxpayers' money. There's no other way to put it, y'all. They can completely waste taxpayers' money sometimes. But y'all hit the comment section down below. Let me know what y'all think about this whole situation for real. And yeah, we'll catch y'all on the next go round. Straight Talk is out.
Yo, if you haven't already, do me a big solid. Hit that subscribe button for me, y'all. Tap that little bell notification icon so you get notified with all the latest content, updates, and information from me, Straight Talk TV. Hit that like button, let YouTube know you rocking with this here content and you want to see more of it. And yeah, y'all, let's jump into this.